So hello and welcome to anyone and everyone just joining us. I am Dr. Joelle Grogan. I am a senior lecturer at Middlesex University, London. I'm also a research fellow at the CEU Democracy Institute. I'm also co-director of the Good Lobby Professors, and I am the creator of Sticky Tricky Law on Twitter. So I have a bunch of titles after my name because I'm very enthusiastic about law and legal study. So again, welcome to those people that are still just joining us. We're going to start the lecture probably in about 2-3 minutes, just to give anyone else an opportunity to join. What we're going to be doing today is pandemic law, so the law regarding pandemics, and very specifically about the rule of law and pandemic law, which is one of my areas of specialty. So again, more welcomes to those people that are just joining us. I am still, as I was 2 minutes ago, I am still Dr. Joelle Grogan and a senior lecturer in law at Middlesex. In terms of what I do in the university is I am head of European Union law in the university. So it's, as you can imagine, a very, very fun subject to be head of, EU law in a British university. No more so because it's very, very complicated right now and it's very fun. I was often in the news. So again, welcome to those people just joining us. We still have a few people connecting. We're going to wait another 2 or 3 minutes before we start this lecture on pandemic law. What I would say in terms of anyone who has now joined us and anyone who's listening in is we have a Q&A function. I'm here to answer any and all questions that I possibly can with regards to the law degree and with regards to anything that you hear during the lecture. So if you have any questions, jot them down now in the Q&A and I will answer them after the lecture is over. So we're going to start in about 1 minute when anyone else has joined. But again, for hopefully the final time today, hello everyone. I am Dr. Joelle Grogan. I'm a senior lecturer at Middlesex University, London in the School of Law. I'm head of all of the European Union law programs at the university. And I am also a bunch of other things. I'm like at CEU, I run Sticky Tricky Law and I run the Good Lobby Professors. So I think the number of participants has now stabilized. I'm going to pause for about 10 seconds. So the wonderful education liaison can add any other information that she sees fit before I start the lecture on pandemic law. So anything that we need to add before we start?
Hi everyone, welcome to the pandemic law talk given by the lovely Joelle, who's an amazing lecturer, as many other lecturers are amazing in our university. Just a quick one, at the end of the session, you guys will receive an email and you can even play this recording on demand. But there will be more information in the email regarding the recording should you want to see it again or listen back to it. Back to you, Joelle.
Great, thank you so much. Welcome. What I'm going to be talking about for the next 20-25 minutes or so is pandemic law. So I'm going to be focusing on it in terms of a very specific frame, which is the rule of law and pandemic law. So we're going to give first a brief introduction to the concept of the rule of law, which is a very, very important value which underlines the legal system here in the UK. And also just generally, it's a very important principle or value that underpins law and legal systems throughout the world. And then I'm going to talk specifically about the complexities or the challenges that the COVID-19 pandemic has presented for law and legal systems, not only here in the UK, but worldwide. So first off, what do we mean when we talk about the rule of law? What do I mean when I say it's an important value? Now, if you're in any way interested in studying law, then you might have come across this idea before. But the rule of law is actually something that's a very, very old principle. It's a very old idea. We can trace it back to Aristotle in the 4th century BC, who essentially has the idea that no one is above the law, that we are all subject to the law, that people are appointed only as guardians or servants to the law. So we shouldn't, or well, people in charge shouldn't be using the law just to abuse others. In fact, they are applying the law because it is above themselves. They can't use it and abuse it. We have within the UK constitutional system, we have it tracing back even to Magna Carta. So one of the first versions of Magna Carta in 1215, the first iteration of it, the first publication of it, had the idea that to no one will we sell, to no one deny, or deny or delay right or justice. We trace this back to the idea again from 800 years ago, that we should be able to access justice, that if we have rights in law, we should be able to have them protected, that the law should protect us. More recently, if we start skipping through legal history, we even have the great A.V. Dicey, again here in the UK, giving one of his first principles of the rule of law, that no man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. Now that is a very fancy, very technical legal way of saying, I cannot punish you for a crime that didn't exist. I cannot take something from you unless it is in the law that I can do so. I cannot behave arbitrarily or with my own discretion, even if I claim to be in charge. So very simply, the rule of law is something that's a very foundational principle. It's the idea that nothing and no one are above the law, that we live in a legal system and that can protect us. It can protect our rights. So we start thinking about, well, we have this idea of the rule of law, but what does that actually mean in practice? What kind of principles or values should be followed by the idea of the rule of law? Now, very helpfully, we have a wonderful, wonderful former judge who is called Tom Bingham, who created the Bingham Center for the Rule of Law. And in his book, The Rule of Law, he outlined 8 fundamental principles. So these are principles that explain what we mean when we mean the rule of law in the context of the UK. So rather than go through these 8 different principles, what I thought I'd do is just focus on 3 of them and make them as simple as possible. So we're just going to look at 3 different principles of the rule of law. The first principle we have is the principle of legality. So very simply, what legality means is that government or ministers or the prime minister or, well, anyone exercising legal power, so even a policeman, say, they can only use the power given to them when it is based on law. They cannot simply exercise their discretion. So, for example, if there is a law that says the minister for parks can decide who is allowed to enter a park, then the minister can't say, well, I'm going to ban anyone and everyone from owning a dog, because that is not within the law. That is not what the law gives power to do. The law says you can decide who enters a park. The law does not say you can decide who owns a dog. So very simply, the principle of legality says that government and any state body, anyone in the country, any minister, any council, any authority, any policeman, any policewoman, any police person, any member of the police force are bound by the law. They cannot just simply decide what the law is. They are bound by it. They have to act within the limits of the law. So our second principle, again, which relates to the rule of law, is the idea of legal certainty. Legal certainty is simply the idea that we should know what the law is. It kind of makes sense when you think about it, because if I don't know what the law is, and if I can't find out what the law is, but I'm still punished, that seems wrong. That seems unjust. So if say the government decided to create a new crime, which said that anyone with red hair has to go to jail immediately, and they like wrote it in a book, and they put the book in a case, and they put the case in a building, and then they hid the directions to the building. If I was arrested and then put in jail, well, I would say, well, how on earth could I possibly have known that it is now illegal to have red hair if the document saying that it is a law is locked away in a room that I've never heard of in a place that I don't know? So very simply, the idea of legal certainty is that law should be accessible, it should be prospective. So if you create a new law, it can only apply in the future, it cannot be applied in the past, that it should be clear and it should be predictable. So I should be able to know what the law is that applies to me. If we want to live in a legal system, if we want to live in a place that has law, then law should be accessible, it should be understandable, it should be clear, and it should be prospective. This is just kind of almost simple ideas of justice or effectiveness of law. The final principle that I want to talk a little bit about is the idea of equality before the law. Again, an idea that seems very straightforward when you think about it, which is the idea that no one and nothing, if no one absolutely at all, I need to emphasize, no one is above the law, that we don't have people with special privileges that can just ignore or avoid law. Law applies to everyone equally. It doesn't matter who you are or where you're born or what you do. Law applies to you because it applies to everyone. It applies to everyone equally. So again, these are three principles that are very important foundational principles of the rule of law, that we are bound by the law. We can't just decide what the law is willy-nilly, that law has to be certain and understandable so we can follow it, and that everyone is subject to the law. You can't decide that you are not subject to the law. So what does that mean when we start talking about pandemic? So pandemic, first and most importantly, is an emergency. It's an emergency situation. And in emergency situations, the law can be applied in different ways. We have special law for emergencies. It's often called emergency law. In many, many countries throughout the world, they have what's called a state of emergency. So this is a special regime that can be declared by the government, saying that we are now in a state of emergency. So different laws, different rules apply. In a state of emergency, often the president of a country, so for example, the president of France, can make special laws and can make special measures and apply them throughout the country. That normally these laws or normally these measures would have to go through Parliament, and sometimes normally they wouldn't even be allowed. So in normal times, a president or a prime minister or government cannot tell people that they're not allowed to leave their homes. They cannot tell people that they're not allowed to go certain places. They can't close schools, they can't close businesses. In normal times, so many of the things that we saw in pandemic cannot happen. Because again, if we think back to the idea of legality, there are no legal powers that say that a prime minister can ordinarily do this. So when we think about crisis and emergency, it allows for exceptional use of power. So extraordinary emergency power. So that's one kind of spectrum. It's one kind of power. On one end of the spectrum is this idea of emergency power. And so many countries throughout the world, about 52, 54% of countries throughout the world declared a state of emergency. They said the pandemic is so concerning to us, it's so immediate to us that we need exceptional powers in order to be able to deal with it. However, a large number of countries, again, if you were doing the maths on that, it was about 46 to 48% of countries worldwide said, we're not going to use emergency power, because we are instead going to use ordinary law, ordinary powers. Now, ordinary law or ordinary powers is the law we kind of have every day. And it's subject to the normal restraints, the normal constraints, the normal processes for making law and for observing law. So as you would be finding out in the first year of your law degree, you would see how law is made, that it passes through parliaments and that often it is interpreted by judges. And that is an ordinary approach, an ordinary process of law. So we had a situation in which many states did not declare a state of emergency. And one of the really interesting things, at least from my perspective, when I was working on emergency law globally in the context of the COVID-19 pandemic, is the huge number of reasons why people did not declare a state of emergency. So if there is an emergency, surely you need emergency power. I mean, that follows. If something has to be reacted to very quickly because it is an emergency, surely the powers that you need have to be emergency powers too. Well, we have lots of different countries that did not declare an emergency for, again, very different reasons. For example, in Japan, there is no constitutional state of emergency. So in law, state of emergency does not exist. The reason is that emergency power can be abused. If you think about it, when law can be used in an exceptional way, allowing for this restriction of fundamental rights with very few safeguards, with very few checks by parliaments and very few checks by courts, then it opens up the possibility of abuse. That governments will use emergency power for their own benefit, and often to the detriment for the worsening of situation for many citizens. So Japan, in the post-World War II constitution, said we don't want emergency powers to exist. If it doesn't exist, it can't be abused. Another example was in the Republic of Ireland, where the constitutional state of emergency didn't imagine a pandemic, that the law does not imagine a pandemic as being an emergency. So the people who were drafting the constitution, who wrote the Irish constitution, couldn't sit there with their imagination and think, oh, what happens if we have a global pandemic? Will we need emergency law for a global pandemic? And this is the same in many countries that didn't imagine natural disasters like a flood or a volcano as being something that needed emergency power. And of course, again, that principle of legality, if I haven't given the power in law, then it can't be used by government because we are constrained. We are constrained by operating within the law. Another reason, and this kind of also relates to the Japanese example, is that there is a very negative historical experience of the misuse or abuse of emergency powers. So in India and in Bangladesh, the memory of country governments misusing or abusing power, of using power very badly, has left this impression of the among politicians that they shouldn't use emergency power. Because if their electorate, so the people voting for them, see them using emergency power, they might think, hey, are you just as bad as those people in history? That using emergency power is a bad thing. And because it is a bad thing, we shouldn't use it. So even if it's something that is more appropriate, that could be used better than ordinary law, we shouldn't use it because we have very negative historical associations with the abuse of emergency power. Another example is a political unwillingness to declare a state of emergency, a political unwillingness to even think of the emergency of the COVID-19 pandemic as being an emergency. So in Indonesia, in Brazil, there was a sense among the federal governments, I'm getting a very blue light, so I'm going to turn off some screens around me. There was a sense in Brazil and in Indonesia that the COVID-19 pandemic is not a real thing, that it's basically a flu, and who needs to use emergency powers in response to a flu? So there was a political unwillingness to actually consider the COVID-19 pandemic as a pandemic. The final few examples that we have of why countries did not use emergency powers are, well, here in the UK, the Civil Contingencies Act was not really considered suitable. That the government looked at the act and they thought, this is not really the kind of law, the kind of powers that we need to effectively respond to the COVID-19 pandemic. So we're just not going to use it. What we're instead going to do in the UK is introduce the Coronavirus Act 2020. We're going to spend only 4 days creating it for a 300-page document. And as someone who sat there trying to read 300 pages of very hastily drafted coronavirus legislation, I can tell you it's not an easy thing to do. I didn't get through more than 50. But that's the choice that was made in the UK, a new form of legislation, a Coronavirus Act 2020, and also relying on pre-existing health legislation. So again, here in the UK, we largely relied on a 1984 Act for the powers of lockdown that we saw throughout England. The final two that I want to give an example of are first in Egypt. Well, they couldn't declare a state of emergency because they were already in a state of emergency. Essentially, Egypt has been in a state of emergency more or less constantly with a few breaks since 1967. So there no new state of emergency could be declared because they've been using emergency powers for 50 years. Finally, what we did see in, for example, in France was the creation of new states of emergency. Essentially, France looked at the existing law and they said, you know what, this is not suitable. We're going to create a whole new law during pandemic. And we're going to make this a state of a health emergency. We're going to give ourselves all sorts of new powers for the government, highly discretionary powers. And this is how we're going to solve the COVID-19 pandemic. So as you can see, there was actually a wide range of reasons why some countries did use emergency power and some countries did not use emergency power. I don't want to get into it because it's a lot of fun, but it's a little bit complicated. But essentially, the huge range of powers that we saw across the world range from emergency to ordinary. It ranged from very, very, very constrained, very limited powers to very open discretionary. Essentially, government, do what you want. Do anything that you think is appropriate in order to tackle the COVID-19 pandemic. But we also saw a third aspect, a third range of countries that were very, very legalistic. So you can, you can only do certain things under the law, to countries that were extra legal, which actually means not legal. It means they tried to operate outside the law. They tried to operate in a way that was not allowed in law, which is another way of saying unlawful, but we're going to call it extra legal because that's the appropriate term in this context. So let's start looking about some of the issues that we saw in the COVID-19 pandemic when we start looking at pandemic law and the pressures that pandemic law created against the standards that we've been talking about in terms of the rule of law. So we can start from the principle, the axiom that we should always follow the rule of law because it makes legal systems better. It's an important value of legal systems, and it means that law functions better, law functions well. So the first, that principle of legality, again, if we remind ourselves, it says that state action is carried out in accordance with law, not discretion. Discretion means I do what I think is best. If I have discretion, it means I can make my own decisions. Whereas if I'm limited, it means that I can only make certain decisions within certain limits. I cannot exercise my discretion. I have to do what I'm told to do, not what I just want to do. So that's the principle of legality. But one of the huge pressures in emergency is that it's, well, an emergency. In an emergency, there's a pressure to act as soon as you can. In pandemic, it's a matter of life and death to make decisions as a government to act as soon as possible. So the pressure to act can come in conflict with the principle of legality if there are no legal powers that you think you need. So for certain countries, there was a sense that, well, they wanted to quarantine people, they wanted to lock down people, but there was no law for that. This hadn't been imagined. No parliament had thought previously that we will lock down a country. No previous parliament had thought we will create a statute which says that a minister can decide that nobody can leave their house. In fact, if we had said that to any lawyers 5 years ago, all the constitutional lawyers would be scratching their head thinking, what? That's absurd. How can you imagine that? But we did. We found that. We found a situation in which this conflict means that we have to fall back on further ideas and further principles for how we try and balance this. Balance the principle of legality with the necessity of action. And very often we think about it in terms of what's called proportionality. So if something is proportionate, it means you're only doing what you have to do in order to achieve a legitimate aim. So that means that I am only doing what is absolutely necessary in order to save lives. I'm not doing more than that. I'm not trying to introduce other policies or introduce other politics that I like just because they're my own politics or my own policies. No, I'm only doing what I absolutely have to do in order to achieve the aim that is justified, a justified, correct aim. So we have that as a kind of way of kind of acknowledging the difficulty or the challenge of a situation of emergency, that we have legality, but we need to have proportionality, necessity, and also limits, that there must be limits always to what governments can do, even in an emergency. The next element that we often came across, and I'm going to try and give some examples here, are, well, uncertainty. That at the very beginning, especially at the very beginning of the pandemic in 2020, no one in the world knew what to do. No one in the world knew the best course of action. However, just because we don't know the best way to deal with a viral pandemic doesn't mean that the importance of legal certainty is less. That in order to follow law, especially when it comes to fines for being out at a certain time or going a certain place that you shouldn't, or breaking a lockdown, it's so essential and so important that you are still able to know the law that applies to you. That the law starts to break down if we don't have legal certainty. If one police force in one part of the country thinks the law should be applied in one way, and a different police force in a different part of the country thinks it should be applied another, this breaks down the law because we don't know who's right, but also people could be penalized in one country and not penalized in another. This, again, it breaks the law. It means that we don't have good trust in the system. The system doesn't work well. One of the examples that we had in the UK for some of the reasons, for some of the sources for this uncertainty in the context of the pandemic, were how fast measures were being introduced. One example that we have in the UK is there was a £10,000 fine for breaking quarantine that was applied. So it came into force. It was law within hours of being introduced into Parliament. So in the afternoon, I think it was like 4 o'clock in the afternoon, the statute from the minister said anyone who breaks quarantine is subject to a £10,000 fine. And this is going to be applied by our police forces from 8 o'clock tonight. So unless you are like me and a massive law nerd and love following things that the Parliament are doing, and we're following pandemic law, there is no way that an ordinary citizen, an ordinary human, an ordinary person living in the UK could possibly know within that 4-hour period that suddenly they were at risk of £10,000 being fined to them. So this is one of the challenges. Another challenge that we saw in the UK is the fact that health is what's called a devolved competence. So Scotland, Wales, Northern Ireland, and England, that's not geographically where they all are, but I'm sure you know what I was saying. But all the different countries that constitute the United Kingdom all have their own policies with regard to health. So the administrations, the government in Scotland, the government in Northern Ireland, the government in Wales and England all decide their own pandemic law. So we had 4 different regimes, which became very complicated when, for example, the UK lifted measures, but Scotland kept them. So if you were living on one side of the border and working on another, suddenly you could be punished with criminal law, 10 minutes in one direction, and have no consequence 10 minutes the other direction. This is a huge problem for legal certainty. The final point is equality before the law. Again, this is the idea that no one, absolutely no one, is above the law. This has been huge in the news recently because we have a situation in which those that made the law are questioning whether or not they are also subject to the law, or if they've interpreted the law correctly, or who governs the governors. So the consequence of this is, well, essentially the question of whether or not it is following the rule of law for those that create the law to also be subject to the same standards which they themselves have set for others. As I am aware, wow, that is exactly 30 minutes. Okay, so that's exactly a 30-minute lecture giving you a flavor of some of the ideas that we talk about when we talk about law, especially the context of the rule of law and pandemic. I will tell you immediately that we do not have a pandemic law course in Middlesex University because it's not required by the Law Society. And I don't think the bar or if you want to become a solicitor will ever consider it. But it is certainly a fascinating topic to consider, the idea of law during an emergency. And it's something that I'm an expert on. But that is the end of this little mini lecture. So what I thought we could do for the next 20 minutes or so is just talk about either the topic of the lecture, so pandemic law, or if you have any questions whatsoever about law at Middlesex University. If I am not able to answer them, I'm going to look over at our wonderful education liaison, who I don't know why I mispronounced that. Our education liaison, and see if she has a good direction for where you could find out the information. But no doubt it will all be online. So if you have any questions about a law degree, if you have any questions about what it's like to study law, now is the time and opportunity. I promise I'm not scary, and I tend to ask and answer all questions. So we have a question. Is the LLB honours degree from the University of Middlesex a qualifying law degree that contains the 7 foundations of legal knowledge? Yes, it is a qualifying law degree. Yep, we do have a qualifying law degree. There is a complexity here for anyone who is considering going and becoming a solicitor, which is that the regulations are in the process of changing. I say that because they've been in the process of changing for as long as I've been lecturing at Middlesex, but there is going to be an introduction of what's called the SQE, or the Solicitor Qualifying Exam, which means that the idea of a qualifying law degree disappears. But what we will be seeing in Middlesex instead is preparation for that exam, that you'll still be learning law, you'll still be learning very, very important skills and foundational knowledge and all the aspects that you need to become a solicitor, but you'll also be training for the SQE, the Solicitor's Qualifying Exam. The reason for the SQE is they're trying to open up access to becoming a solicitor by saying that there is no more a qualifying law degree, it's just qualifying experience. But we're still going to be looking at the qualifying examination and preparing for that examination to become a solicitor. The bar is different. The bar, it's still a qualifying law degree. Can you choose the topics for law to study at university? That's a really good question. There are certain foundational courses that everyone has to study. So everyone has to do public law, everyone has to do introduction to legal methods. Currently, I think until next year, so this year's first years, I think we'll have to do it. So currently EU law is a mandatory subject, but that's going to be changing. I'm not sure if that's a good thing or bad thing. I think EU law is fascinating, and it is guaranteed for very lucrative jobs for decades to come because of Brexit, but that's a separate issue. There are certain courses you have to do, so certain foundational courses you have to do, and then you have a bunch of choices. So you have a lot of choice as to what you study in especially the 2nd and 3rd year. So some choices include, say, consumer law, international law, advanced issues of European Union law, human rights, commercial business. So there's a full panoply of courses that you can take, that you can choose. Because I know that a lot of students like to specialize in certain fields or certain areas of law. So again, choosing your own modules within the course. I'm just going to reiterate, there are certain like foundational modules you have to do because these are a qualifying law degree. You have to have certain like tort and criminal law are also things everyone has to do. But then you get more choice as the law degree continues, and you can specialize in areas, or you can be a generalist. So you can do different types of law degrees. You could do human rights and business, or actually, human rights and business is a really good combination because they go well together. So you have to do certain courses, but then you can choose whatever else that you would like to do, depending on what you find interesting. Are there currently any joint honor law degrees offered at Middlesex? To the best of my knowledge, there were, but this is a question on administration that I'm not an expert in. So I will blink over at our educational liaison to see if she has any more specialist knowledge on that, of joint honors law degrees. Otherwise, I'm going to say Something else? Looking over at our education liaison, do you have an answer to the question?
Yes, I do. I'm going to type it down so you can proceed with the next question.
Amazing, amazing, fantastic education liaisoning from our education liaison. So that question will be answered. What stands out in a law? Oh, sorry, that disappeared on screen. What stands out in a law personal statement above others? Ooh, such a good question. Such a good question. Genuine interest. Like, I think it's very easy for people to say, like, I'm really passionate about law, I'm super interested in law, but showing that is a lot, it's always a stronger case to give evidence. So instead of saying something like, I'm really interested in the law because it's really interesting, that doesn't tell me anything. You can say, I read an interesting newspaper article about a case which discussed whether or not a person has a right to go onto their neighbor's land. And this is really something that appealed to me because I thought about this topic in this other context. Or it could be, I spent a day in court and listened to this case, and it was so interesting that they decided this, and I think it's interesting because of that. So showing genuine enthusiasm about law always stands out to me. It's always the difference between saying something with evidence, saying something with reason. So saying something with by giving an example of why you think something is interesting or why you want to do this, versus just saying law is interesting or law is cool or law is nice. So genuine interest to me always stands out. One other kind of minor thing, which it didn't happen in Middlesex, it happened in the last university that I was in, which is if you write a personal statement, make sure that you wrote the personal statement. So don't get someone else to write your personal statement, because it can lead to a very embarrassing situation, which is what happened to this poor student that I was talking to many years ago. I found out that they did not write their personal statement, and it was embarrassing for everyone involved. Don't do that. So yeah, what stands out in a law personal statement above others? Genuine interest and evidence interest. So if you put forward a position, give a reason for your position. This is also good legal practice. So if you want to become a lawyer, you don't just assert something, you have to give evidence for it, you have to give reason for it, you have to give analysis. So it's the difference between I like stuff versus the reason that I like things are because of this reason, that reason, that reason. So evidence your conclusions. Good. Which A levels do you think are the most useful, beneficial to pursue a law degree and then a further career? Ooh, this is so good. I had an answer for this that's completely different 10 years ago. And now I've been in law long enough that I'm like, what I think is always very strong is anything with a very high degree of writing and reading. So history and English are very good for preparation for law degree, because you have to read an incredible amount of information. If you don't like reading, reconsider law. And you have to really engage and analyze huge quantities of information under very tight constraints, especially if you want to be a barrister. Because if you want to be a barrister, you get huge amounts of information that you have to process very quickly. But the big change, I would say, since I've kind of been working in the field for so long, is how important reason-based subjects are. So for example, and you wouldn't think this, maths is quite good for lawyers, because law is entirely about logic. The process of a law applying to a situation is logic. So for example, in criminal law, the definition of murder is the intention to kill or action. Sorry, it's been a few years since I taught criminal law, but it's essentially conduct causing the death of another human being under the Queen's peace with the intention to kill or cause grievous bodily harm. So that is just a series of steps that you have to apply to a situation. So it's conduct. What did they do? Causing death. Did it cause someone to die under the Queen's peace? Is it in peacetime, or is it in war? Is it a war situation? With the intention to kill or cause grievous bodily harm. So did the person who did the action intend to cause very serious harm or to kill the person? So there are 4 steps. Do you have the 4 steps present in the situation? Then you can conclude that it is murder. So the reason I highlight that is, especially in the context of criminal law and tort, having a quite logical brain, a mathematical brain, is actually something that's quite helpful. So in conclusion, there are no specific courses that I recommend if you want to study law, but I would say that it is good training for you to do something that involves a lot of reading, a lot of writing, because that's what you have to do in a law degree, but also something that is very, very, very rational and very logic based, where you're actually constrained. So maths can also be something that's quite convincing. What I would say is law is a very specific way of thinking, a specific way of reasoning. So you need to have a very, very logical approaches. Not to say that it's not very creative and imaginative. That's certainly also my experience of the fun of studying law. Why study law at Middlesex? Because we're awesome. So I'm very tired and I haven't had enough coffee, but I do mean very sincerely. One of the reasons that I really like Middlesex as a university is the teaching staff, the teaching team, the colleagues that I have are really, really lovely. They're really, really accessible. They're very, very dedicated to teaching. They're very, very dedicated to being accessible to students. So one of the challenges in many other universities is the lecturers are a bit more distant, so it's a bit more difficult to get support, to get access. What I'd also say is Middlesex is about access. It's trying to ensure a good level of access to law and to understanding. So there's a lot of facilities supporting students. But obviously from my very biased perspective, I think my colleagues are awesome. Like I really like my colleagues. And I realize I'm a staff member sitting there saying my colleagues are awesome. And I can see how dedicated they are to teaching and how dedicated they are to their courses. So I love my colleagues. And the campus is quite nice too, I have to say. It's a nice place to hang out. I was there this morning and it's nice and sunny. So insofar as the weather means anything, nice weather and Middlesex is quite a nice combination. Good. Next question. Do you recommend taking law as a degree despite not being sure whether you want to pursue it as a career? Is it worth it just to gain skills? Such a great question. I can use my own example. I started my first law degree. I have 3. I started my first law degree. Sorry, that was like, look at me. I have 3 law degrees. No, I started my first law degree convinced that I was going to become a barrister. I was certain that I was going to be a barrister. And I finished my first degree and then I had an offer to go study a master's degree in a very, very good university. And I was like, well, definitely going to do that. So I did my master's in law. And while I was doing my master's, I spoke to really fascinating people and I loved thinking about law. I loved arguing about law. I loved the whole environment of law as an idea to discuss. And I was offered a PhD. So I jumped at doing a PhD. And then I just enjoyed it so much that I stayed in academia. I stayed thinking about law rather than going and becoming a barrister or a solicitor. The reason I mention that is I have in all the different courses that I've done, a majority, I might say, of students did not become a solicitor or did not become a barrister. A large number of them went into politics, they went into journalism, they went into human resources. A few people went and started working for Google. I know a novelist. So the reason I highlight that is the law degree is a very, very, very good degree for giving you the option of the professions. So it's still a qualifying law degree in many ways, but it's also very recognized in terms of what skills it gives of reading, of analysis, of logic, of an in-depth thinking about topics, of argument, of presentation, of advocacy. So the kind of skills that you get in a law degree are applicable across a very wide range of careers, not just the professions. So I'd say most people would go to public service or NGOs or business or journalism or, again, that novelist, which was really cool, actually. She's written her second book now. So with obvious bias, because, again, you're asking someone with number of law degrees whether or not it's good to study law, I would say it gives you a lot of choice and opportunities that maybe other degrees wouldn't as much. But it is a good foundational degree to go on and do almost anything else. with certain caveats, you can't become an engineer unless you go and study engineering. When pursuing a law degree, did you find that what you assumed was going to be the best module wasn't? And was there a surprising, oh, I like this question. Okay, anonymous attendee, lovely name. I really like this question. So when pursuing a law degree, did you find that what you assumed was going to be the best module wasn't? And was there a surprising module that interested you more? Thinking criminal law would be the most interesting, but human rights is more engaging. Ah, man. Yeah, you spot on. I did teach criminal law, but when I was doing criminal law in my undergraduate degree, I thought it was going to be the most interesting thing ever. And I was so excited, and it's not. A lot of people love criminal law. In fact, a lot of students at Middlesex, I didn't study Middlesex, but a lot of students at Middlesex love criminal law. They absolutely love the course. But when I was an undergraduate, I thought I was going to love it. I thought like murder and fraud and theft and robbery, this is going to be so exciting, but it's not. It wasn't for me. I found it really, really boring. In terms of like surprising, European Union law, actually. I never thought about EU law before I did it, and I loved it. I found it fascinating. I found it a mixture of philosophy, of economics, of politics, of history, and it also was an international ticket. So I knew that by specializing in European Union law, I could go anywhere in the EU, and I did at that stage. So yeah, I assumed that I was going to love criminal law and I was going to be a barrister. And now I'm sitting as the head of EU law in a university, and also actually a specialist in pandemic law and crisis governance. So you never know where things are going to take you. Thinking that I would find EU law really, really, really boring in university. So you never know where things go. We've lots of questions. Right, next up. Do you think it is oversaturated, hard to get a training contract? Yes. Yes, it is. Law is an incredibly, incredibly, incredibly competitive environment. It's a very, very competitive field. The reason for that is that salaries are very lucrative. So you have if you get into a good firm, or you get into a good chambers in the bar, it's a very lucrative career. People earn huge amounts of money in law. And as a consequence of earning huge amounts of money by working in the law, it's a very, 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 very competitive field. That's not to say that's impossible. We have people who have gone to fantastic firms and gone to qualify the bar. But what I would say is they acknowledge that getting a place on a training contract or getting pupillage for the bar is not just having a very good law degree, having a very good score in their law degree, but it's also all the other experiences that they build onto it. So it's the clubs that they join in the university, it's the jobs that they do at work, it's the wide range of jobs that they do. So they don't just do law degree work or law work and law experience and law volunteering, but the wide range of experiences that they use to build into, I am ready and capable and going to excel in a training contract. So if you're going to take any advice from today, it's build up your CV, build up the amount of experience that you can have if you want to become a solicitor. What I'd also say is there's a fantastic Wood Green clinic that Middlesex is associated with, in which students volunteer at a law clinic, and that's great skills, great experience, and it's great to put on your CV if you are wanting a training contract. So it is very, very difficult to get a training contract, but that is the same no matter where you go to. It is a very, very competitive field, which kind of traces back to the idea of, if you want to study law, it's a great, fascinating degree. But if you are just thinking about it in terms of one outcome, then really, really, really think hard about it. Is a law degree a good degree to have, even if you want to do real estate later? Guess what? You do land law, which a lot of students find a bit tough, but land law is all about buying and selling property. Again, a law degree is a very good basis for a lot of different careers and a lot of different opportunities. You might have a clear idea of what you want to do. And if you have a clear idea of what you want to do and you're really interested in it and really invested in it, then figure out what the best course of action is to achieve your goal. If it's a law degree, great. If it's not a law degree, if it's something else, focus on something else. What I would say is, I find, obviously I'm a big law nerd. I find law fascinating, and I I really, really enjoyed studying it, but I also recognized it was incredibly difficult, that law degrees are very, very, very challenging. They're intellectually challenging, they're demanding in terms of your time and attention, and they really ask you to develop skills very, very, very quickly. And a lot of students find law very, very hard. That said, it's a great degree that can take you in so many different directions. So my advice would be, if you have a clear idea of where you want to go in your career and where you want to go in your life, trace backwards. And if it includes a law degree, yep, brilliant, big fan of law. But if it doesn't, then focus on your own career path. Don't do law just because you think it sounds cool. What type of work experience do you think is helpful before applying to university? Very simply, almost any experience, almost any work. We had a student who was working in a nursing home, excuse me, was working in a nursing home, and it was again giving very good skills of time management, of interpersonal skills, of engaging with people. These are all relevant to a law degree. They're all relevant to the future. So law experience is obviously a clear example. So working or volunteering at the courts, shadowing lawyers, shadowing barristers, shadowing judges, that's all great work experience. But just your ordinary work, if you have a part-time job, is also immediately relevant to a law degree. They're all very, very similar and transferable, interchangeable skills. Are there many legal jobs in medicine or pharmaceutical development? Oh, yes, there are. Basically, very, very simply, if you can imagine something, there is law associated with it. For example, the closest book to me, it's not a law book, I promise. The closest book to me right next to me on my computer is Don't Worry, Little Crab, which is for, I assume, toddlers and babies. I haven't read it yet. I'm sure it's fascinating. I can tell you right now that this book will have a huge number of laws and regulations associated with it, everything from copyright law, as in the author who wrote it, to regulations regarding that color and regulations regarding that paper. So there will be laws that say that this paper cannot be toxic if it is chewed by a toddler or it's chewed by a baby. Right over to contract law. So I didn't buy this, as evidenced by the fact that I haven't read it, but contract law will govern the sale of this book to the person that gave it to me. So anything that you can think of has law associated with it. And if it has law associated with it, there are lawyers who are associated with that law. Copyright is a super fun, interesting area, along with trademarks and anything intellectual property associated, which is relevant to medicine and pharmaceutical development, because intellectual property and data governance and regulations regarding pharmaceuticals and medicine, or even medical negligence, are huge fields of law. So yes, absolutely. In fact, I think medical law is actually something that's offered in Middlesex. So yes, there are. Ooh, so many questions. So where are we? Would work experience in business, finance industry look attractive on a law personal statement, or is it important to relate your work experience to law? You can relate almost any experience to law. Business law and finance law are also immediately relevant to the law industry or the legal industry. In fact, a lot of lawyers then will go on and work in finance, and they'll go on and work in business. So the question, though, if you're looking at a law personal statement, is justifying it. You can have almost any position, you just need to justify the position. So if you say something along the lines of, I worked in a business and I worked in the finance industry, and what I found really fascinating was the legal regulations governing the finance industry because of this reason or because of that reason, that's quite convincing. And that's something that's quite interesting on a personal statement. So you do need to relate the experience to law, because you're trying to convince the reader that they should admit you, that your personal statement is saying that you are ready and prepared and able for a law degree. So yes, it's important that you always relate your work, no matter what type of work it is, to your aim, which is getting a place at a law school. Now, due to Brexit, does a law degree in the UK still hold the same value abroad in the rest of Europe? Sadly, no. In EU law, there is and this applied to UK law degrees before 2020, there was a legal obligation that all member states recognize the qualifications of other member states. So if you got a law degree in the UK before 2020, you could bring that law degree to France, and France would say, I recognize that it's a UK law degree and you're able to do these certain things within these certain regulations. Obviously, that protection is, or that protection, that right has now gone. So there is no legal obligation that law degrees in the UK are recognized. That said, I mean, obviously, that said, if you have a UK law degree, it's still a UK law degree. So if you apply to businesses in other parts of the EU saying you have a UK law degree, they'll say, yeah, you have a UK law degree. We recognize that you have gained the qualification of a law degree in the United Kingdom. What it does mean, though, is you wouldn't have the ability to practice law in other countries, that the routes that are available to EU lawyers for having EU law degrees would not be available to you anymore. So it's different, essentially. We've lost that legal recognition. Any other questions? Any other questions, concerns, existential crises? No? Okay. On that note, it was lovely to chat virtually to you all this evening. I hope you have a lovely, lovely evening ahead of you. I have a very final question. And the final question is, are there any specific books that could be read before entering university? Tom Bingham's Rule of Law. It's pretty straightforward, and it's just talks about the importance of the rule of law. So check it out. I think it's good. But generally, any reading is good. Like any reading at all is a very good thing to do to prepare for a law degree. Just absolutely any reading. On that note, it was delightful and wonderful to chat with you all. Hope you have a lovely, lovely, lovely evening ahead, potentially with coffee. If you're into coffee, that's what I'm going to have right now, and I'm really excited about it. But otherwise, I would strongly encourage you to go and enjoy the beautiful weather. There is beautiful weather in the UK right now. Please go out and enjoy it. Enjoy a nice time and have a lovely evening. Good. All right. Handing over to our wonderful education liaison, if there is anything else here.
Hi everyone, thank you so much for joining us today. We really appreciate it, and I hope you enjoyed this informative talk. I can see that the questions were really amazing, which shows that you all have shown really nice interest in studying law, and we wish you the very best for the future and hope to see you study with us as well. Take care everyone. I'm going to end the session now. Bye.